Hi everyone, welcome back. This is Mrs. Ragno. In this slideshow, we're going to be covering what happens when a crime is committed from entry to exit, we say, of the criminal justice system. So what happens when a crime is committed? So the first thing is the crime must be discovered. So someone tells that there's a crime that just occurred. So let's just say the neighbor just heard something outside. They think a crime occurred. Maybe they saw someone breaking into their neighbor's house. Usually the police are the first at the scene, so the police will investigate, collect information, interview any witnesses. The crime scene will be documented, search for evidence. All of that information is assembled into a report. A prosecutor who will lead an investigation, they can determine if a crime has actually been committed and if there's sufficient evidence to issue the arrest warrant. If there is sufficient evidence, so maybe somebody noticed there was a break-in, a robbery, the cops get there, they have evidence that there was a robbery, now they're going to issue that search warrant. Once the suspect is arrested, they must be booked into jail. So booking means they will be taking their fingerprints, they'll be taking their information, their photo. That person will be informed of their Miranda rights, and they will be arraigned before a judge, usually within 72 hours. And so that means that the booking will help them to process this person into the system. So booking is a police procedure. It's basically the photographing, the fingerprinting, in participating in coming into the prison system. The arraignment is going to be where the suspect appears in court for the first time. At the arraignment, that's when the charges are brought against this perpetrator, so against the suspect. So the judge will explain the suspect's rights, and the suspect will either enter their plea of guilty, not guilty, or maybe not guilty by insanity, double jeopardy, or no contest. So typically the no contest means they're not fighting the charges, but that's very rare. Usually we're going to kind of go with, usually the person will plead either guilty or not guilty of the crime. At this time, the court can basically appoint someone to set bail, and future court dates are set for this, say, trial. So at this time, basically what happens is if the person pleads guilty, you might wonder, why would someone just plead guilty? There's a few different reasons. There's something called a plea bargain, where maybe somebody wants to plead guilty so that they are going to get a lesser sentence. So if I know that I'm the suspect of a robbery, I know I did the robbery, I know that they're going to find the fingerprints and maybe my car was there. If I plead guilty, I will basically get a lesser sentence. They're going to work with me a little bit better. Whereas if you plead not guilty and you take everyone through this court process, they're not going to take you lightly. You know, you're likely to get a higher sentence. So that is one of the reasons why sometimes you end up with guilty pleas. Sometimes you'll hear about plea bargains. So let's just say this person is going to plead not guilty. So first thing is to determine, is there enough evidence for a trial? In some cases there are, some cases there are not. So the next step is for a crime that's a felony. So let's say this is a murder case. You're going to have a preliminary, also called evidentiary hearing. At this hearing, the prosecutor will present the evidence against the suspect. The defense can cross-examine or then present their own evidence. And at the end, the judge determines if there is sufficient evidence to proceed with the case. If there is, then they'll set the dates for the trial. Sometimes they'll use a grand jury, and that means that there'll be people set to citizens coming to hear about this crime, and if there is a majority vote, then the trial is set and the jury will end up helping to bring about the verdict of this perpetrator. So in the trial, it's not really determining guilt or innocence. There's a lot of things that come into play, but at the end, the guilt or innocence will be determined. The main participants you'll see are the judge, of course, is kind of the one in charge of the court. The big problem, the big thing with the judge is that they will determine the admissibility of the evidence and the principles of law that apply. The admissibility of evidence is very important in scientific language, because what we want in forensic science is to know, is this science valid in the court of law? And there are some cases that have come up in the years that have determined admissibility. So for example, if I said to you, could we use fingerprint evidence in court? Probably all of you have heard of fingerprints, you've heard of blood. There's certain evidence that can be admissible into court as long as the scientific community is on board with it, and as long as it is probative. Probative means that it is a piece of evidence that does mean something. That's going to be very important in terms of will it be allowed into the court of law. But the judge will be the one to determine that. And there'll be some cases that you'll work on this week that have to do with some of these laws. So the jury is the panel of citizens who will listen to all the evidence. The jury is the one who will eventually render the verdict. They're the ones that you're trying to explain the evidence to. The defendant is a person accused of the crime. The prosecution attorney is presenting the evidence to persuade that the defendant is guilty. The defense attorney presents evidence to provide that there could be reasonable doubt and that there maybe is not enough guilt. And then the bailiff is the one that announces the court is in session, when is the judge presiding, and swears in the witnesses. The court reporter records everything that's done in the courtroom so that all of the statements and everything is all very well documented. And the final participants in the trial, the witnesses. There are many witnesses to the crime. Usually there's things like the eyewitnesses, maybe character witnesses, things like that. The expert witness is the most important in terms of forensics, because the expert witness is the one that has specific special knowledge or expertise. So as a forensic scientist, you can be working in the lab to analyze the data, but you can also be called into the courtroom. And usually if you are called as a forensic scientist, you are the one explaining what the science means to the jury and trying to get the jury to understand what it is. Once the jury is chosen, the trial will proceed. So the bailiff will call to the court to order. Everyone will be standing. They'll announce the case. Then they will say that this is the people versus, and then the name or the names of the defendants. The prosecuting attorney will then introduce themselves, present their opening statement. The defense attorney will present their opening statement. And the opening statement is basically to give an overview of the case, what it entails, and what they think is kind of like a brief overview of the crime. The prosecution is going to try to have enough evidence to show that they have evidence that this perpetrator is the one that did in fact commit the crime. The defense will do the same, but they are really going to try to look at the burden of proof beyond a reasonable doubt. And so just remember that the beyond reasonable doubt means that if there is not enough evidence, then you cannot convict. So once both sides have done this, there will be direct examination, cross-examination, and ability to ask questions in response to what is said there. And once this is done, they will kind of go back and forth, keep this going until all the evidence is discussed. Each witness is always sworn in by the bailiff. They are asked to tell the truth, the whole truth, and nothing but the truth. So it's very important that they can only ask questions that were actually introduced in the direct examination. You can only ask questions that are probative and relevant to the case. The items of physical evidence must be introduced during direct examination, and that is where they'll talk about the relevance to the case. So before I had talked about this, but let's just recap. There are some federal rules of evidence that are very important. In order for scientific evidence to actually be admitted into a court of law, it must be probative, which means it actually proves something, and it must be material, which means it actually addresses an issue that is relevant to this crime. So as a witness is being questioned, basically some of the questions that you'll hear are, is it relevant? So hopefully that the testimony, whatever they're talking about, is relevant to this case. You cannot ask leading questions unless when you're cross-examining. When you're cross-examining, you can, but otherwise you shouldn't ask leading questions. You should let the person do some talking. You want to make sure that you are actually talking within the scope of direct examination, that there's not hearsay, that it's not opinion, and it's not personal knowledge. So if you ask something and someone says, I don't have the knowledge, then that is, of course, an objection. So once both sides have done this, there'll be a closing argument, and eventually the emphasis is placed always on the guilt beyond reasonable doubt. So is there a question of this person's either that they did the crime or that they did not? And so there's a strong emotional pull on the jury at this point because both sides are really trying to come up to the verdict. In most criminal cases, what ends up happening is that the jury has to return with a unanimous verdict. Once they reach a verdict, everyone will return, they will read the verdict, and then whatever it is the jury decides is the fate of that perpetrator. or suspect. So at this point, what happens is there either be you can either have a guilty, you can either have, or you would have where there's a dismissal of the case, or an acquittal, we would say. So if someone's acquitted of the crime, they're found innocent, not guilty of the crime. And remember, if that happens, they can never be tried again twice for that same crime. And then there's something that can happen, which is called a mistrial. And sometimes you hear about mistrials if the jury cannot determine. So maybe it's a very split 50-50 and the jury cannot come to a verdict. That would end in a mistrial. And this is a crazy thing, but if a case ends in a mistrial, that means you're going to have to go through the whole trial again with a new jury. So there are situations where that happens. So if a mistrial occurs, then that perpetrator, the suspect, is going to have to go through the whole process again with a whole new jury. So the idea is that hopefully you will end up coming to a verdict at the very end. So I like this to sort of just give you a little flow chart of how justice is administered. And so this is really what's going to happen. So depending on if it's a misdemeanor or a felony, this is sort of the what will happen. In the end, if you're convicted of the crime, there will be sentencing. In the felony world, if you are sentenced, you can appeal. If you appeal, there must be obviously good reason for the appeal. And once the appeal is processed, then eventually sometimes the verdict will have something done again with that. Typically, once the sentencing happens, it's very hard to appeal. Eventually, that sentencing might lead to prison. Sometimes you can get out on probation. Eventually, sometimes you may be released, especially with something like a misdemeanor. Eventually, a lot of people are released. If you have been found guilty of, say, murder in many states now in the United States, there is no death penalty, but the highest that you can have for a sentence would be life in prison. So some of those cases may end up in life in prison, unless there is a state that has a death penalty. But death penalty can take many, many years. So by that time, it's usually a long time in prison afterwards. So this is a good flowchart to show you how justice is administered in terms of the law. I also have another flowchart that I'll be posting in the class, and this will help you as you go through the work for this week's class. All right, thank you. I hope you have a great day.